Good morning, one and all. I am Heli Dubey, currently an intern at ubAdvocate. In this video, I'll be discussing the topic of discharge as provided under Section 227 of the Code of Criminal Procedure. Section 227 of the Code of Criminal Procedure 1973 falls under Chapter XVIII, which contains provisions for trial before a court of session. The said section provides that a judge has the power to discharge an accused if, after examining the evidence brought on record and hearing the party, draws on to a conclusion that there exists no sufficient grounds to proceed against the accused. The section emphatically provides that the reasons for such discharge should be recorded in writing. The pivotal objective of the section is to save time of the court by not involving in a trial in cases where the court is almost certain that there is no likelihood of conviction of the accused. Also, the Supreme Court in the state of Karnataka versus L. Muniswamy clarified that the objective of recording of reasons for discharging an accused is to enable the higher courts to examine the correctness of the reasons applied by the sessions judge in holding that there is no sufficient ground to proceed against the accused. Moving on to the scope of the section, the position of law is well settled that while exercising powers under Section 227, while considering the question of framing of charges, the judge has absolute power to sift and weigh the evidence put forward for the only purpose of discovering that whether a prima facie case has been made out or not. It was further clarified in the case of Union of India versus Praful Kumar Samal that the judge cannot merely act as a mouthpiece or a post office of the prosecution. He has to consider only the broad probabilities of the case and the overall effect of the documents and evidence produced before the court, and not to make an elaborate inquiry into the matter as if he is conducting an actual trial. There has to be application of judicial mind, but only for the purpose of determining whether a case for trial has been made out or not. Therefore, a judge is justified in framing charges against an accused in a case where the material produced before the court, though not properly explained, unveiled grave suspicion against the accused. At the same time, if the judge is satisfied that the evidence produced before him gives rise to some suspicion but not grave suspicion, he is justified in discharging the accused while exercising powers under Section 227. Moving on to the difference between acquittal and discharge, it is important to note that an order of discharge does not amount to acquittal of the accused. An order of acquittal is a judicial decision where, after elaborate inquiry and trial of a case, the innocence of the accused has been established. On the other hand, an order of discharge is given as there is lack of sufficient evidence against the accused to order further inquiry. Discharge of an accused is not a proof of his innocence. A person once acquitted cannot be tried for the same offense or different offense involving the same facts in lieu of the principles of double jeopardy and autre acquit. But in case of discharge, fresh proceedings can be brought before a court if material evidence is discovered, and the discharged person can be rearrested for further questioning. In conclusion, I would like to say the major purpose of Section 227 is to ensure that the Court of Sessions is satisfied that the accusations put forward by the prosecution are not frivolous and that there exists some significant material for proceeding against the accused. The court, while exercising its jurisdiction under Section 227, has only to consider the probative value of the material brought on record, and after examining the same, either proceed with the trial in presence of sufficient material or discharge the accused in its absence. Thank you and have a nice day.